नमस्कार, आदाब, सत श्री अकाल दोस्तों। स्वागत है आपका एक बार फिर से हमारे YouTube चैनल ब्रास फ्यूजन्स पर, जहां हम आपके लिए एक बार फिर से लेकर आए हैं एक नया लेसन।
The complaint was filed against Nawab Hussain under Prevention of Corruption Act. Now, thereafter, what happened is that proceedings started against him, and he was dismissed from service. Now, obviously, he was aggrieved by this decision. So, what did he do? He basically he filed a writ to the Allahabad High Court, and in the writ he contended that my dismissal from service, this is basically a service matter, he said my dismissal from service is not justified and is not a right decision that has been taken, and the reason is that I was not given any opportunity before I was dismissed. Now, when you do administrative law, you would come across a concept of audi altrum partem. Now, audi altrum partem basically means a chance of being heard. Now, this is one of the principles of natural justice, that before you are taking a decision against someone, before you are giving a decision against someone, you are supposed to give that person a chance of hearing, right? And this person said that I was not given any chance of hearing before my dismissal, so that is my ground. And on this ground, he filed a writ. Now, after hearing the writ, the High Court came to the decision, no, his ground is not justified, and he was not given any relief by the High Court, right? Now, thereafter, what he did? Thereafter, this person filed a suit. He filed a civil suit. And in the civil suit, again, he is, yes, Komal, you're right. Here the other party. Yes. No, not the other party. Here the party against whom you are taking the decision. That is audi altrum partem. अगर मैं आपके against कुछ disciplinary action ले रही हूँ, then it is my duty to give you at least a chance for clarifying your position. That is audi altrum partem. Right, Komal? And that's okay. But that is what audi altrum partem means. Fine? Now, what happened is this person went ahead and he filed a civil suit. And in the civil suit, this was against his dismissal from the service. And now what the ground that he's taking is, he's taking the ground that, look, see, we have a principle in service rules, and that is that the authority, the official position who appoints only that of that authority or any authority above that will have the jurisdiction to remove you. जिसने आपको अपॉइंट किया है, वो ही आपको रिमूव कर सकता है, या फिर उसका सीनियर रिमूव कर सकता है. उसका जूनियर लेवल का ऑफिसर आपको रिमूव करने की कैपेसिटी नहीं रखता है. That's a principle that is there in the service rule. Now, in this case, this person filed a suit against his dismissal, and what is he saying? He says that, look, I was appointed by the Inspector General of Police, that is the IG of Police, and it who had the capacity to remove me, but I have been removed by the Deputy Inspector General of Police. That is a rank which is lower than the Inspector General. Since I was removed by a person who was not competent to remove me, it was only the Inspector General of Police who could remove me and not the Deputy General Inspector of Police. So this removal is wrong, and so this removal should be set aside. My dismissal from the service should be set aside. Plus, have you got the facts? Yes, no, maybe. Tell me. Have you understood the facts? Type in the chat box.
Yes,
Type in the chat box or respond. All right, fine. Right? So, उसने पहले एक writ file करी अपने dismissal के against. उसने कहा I was not given a chance to be heard.
Ma'am, your voice is breaking.
Your voice is breaking.
Ma'am, your voice is breaking.
Okay. All right. I think it will be fine now. Okay. Now what he says that I was appointed by the Inspector General, and I am being removed by the Deputy Inspector General. So he does not have the authority to remove me. So my removal is wrong. Fine. So when this case comes to the court, the government, state of UP, basically contends that this suit cannot be sustained because res judicata is going to apply on this suit. Now the issue is that will res judicata apply or not? Now see, if you look at the normal res judicata, class, I think now my voice is fine, right? Class, my voice
Yes,
is fine
ma'am.
now, right? Okay,
Yes,
okay,
ma'am.
okay, fine. So, fine, okay. So, this person, in this case, can we apply normal res judicata? Was this issue that is the removing authority competent to remove it? Was it decided in the earlier suit? No, it was not. In the earlier case, with petition, this case was not decided, right? So now what do? Now, we cannot apply direct res judicata, but the question comes, can we apply constructive res judicata in this case or not? Now, what I say is that, look, the whole principle of, the whole purpose of res judicata is that it is in the interest of the state that there has to be an end to litigation. Litigation should come to an end, right? And the party should not be held, caught with the same litigation again and again, which is going, har ek cause of action ke upar, har ek ground ke upar aap baar-baar ek nayi litigation file kar rahe ho. We want to stop this practice, and that is why you have the principle of res judicata. Now, what happens is, now we have the principle of construct dealt in explanation 4 of section 11. Now, what does it say? Now, it says that even if there was a ground, if there was a ground which was available to the parties at the time when the first suit was filed, but the party ignores to or does not take this ground, then that case later on he is not allowed to file another suit on this ground. This is the principle of res judicata. जो ground आपके पास पहले भी available था, पर पहले वाले सूट में आपने वो ground नहीं लिया, तो कोर्ट presume कर लेगा जैसे कि आपने वो ground लिया था और उसके ऊपर भी res judicata लगा देगा. So that is what precisely happened in this case also. The court said, look, we are looking at res judicata, and here we do find that direct res judicata obviously cannot apply in this case. However, at the time when this person was dismissed from the service, it was well within his knowledge that he is removed by Deputy Director General of Police, right? And who is not the appointing authority. Appointing authority is the IG, Inspector General of Police, and he is being removed by the Deputy Inspector General of Police. So that ground was available to him at the time of filing of the writ petition also. Since this ground was available to him at the earlier time also, he should have included this ground when he filed the writ petition also. Agar usne nahi include kiya, then that is his problem. If he is not including, the court will presume as if this ground has been included, and if he takes this relief further, constructive res judicata is going to apply, and this person will not be given relief, which means his second suit will not be sustained, and res judicata will apply, and the court will not proceed with the case. So that was the decision in the case. Class, is it clear?
Yes, ma'am.
Ma'am,
Any doubts?
Does the concept of constructive res judicata only apply in civil cases or in criminal cases as well?
See, I told you in the last class also, in criminal cases we have section 300 CRPC, right? Section 300 CRPC takes care of this provision that for the same cause of action you cannot try a person again and again. We do not have a res judicata per se, but section 300 CRPC takes care of such situations. Fine, Rahul?
Yeah, no, I was asking more like as a defendant in a criminal matter, if I hadn't raised some facts in a previous matter, could I raise those in a higher court or in like with the concept of res judicata? Like,
See, appellate court always have, we are, please, you have to, I think there is some confusion.
Oh, right,
Just a
okay.
moment, Rahul.
Right.
Just a moment. I think there is some confusion, class, with a lot of you. मतलब आप ठीक से समझ नहीं पाए इस बात को. When we talk about res judicata, we are not talking about appellate.
Yeah, no, my apologies. I realized that.
No, that's okay, right? That's okay. We all have confusion. That's fine, absolutely fine. I'm just clarifying for those who are not asking and still are confused about it. So for the clarification of the entire class, please keep. When we talk about the concept of res judicata, This means the person is not allowed to file the suit in the same level
Your
of
voice is
court.
breaking.
A person is not allowed to file a suit in the same level of court, which means that अगर आपका पहले civil court में था, then again you will not be allowed to file another suit in the civil court. It does not apply to appellate court, which means when you go into appeal, obviously you can take another grounds in the appellate court. Fine, class. Is this concept fine for everybody?
Yes.
Right. Res judicata does not apply for an appeal, from a suit to appeal, but it applies on the levels of same court. All right. Now, any other doubt, anyone in this case? Then I move to order to rule 2. Yes, Rakesh.
Like ma'am,
Yes, sir.
you told me that if there are possible to be two issues in a single case, but an applicant goes with a single issue. Like there are possibility of two issues in a similar case, but he goes with single issue. So you said that res judicata will be applied if we'll go for the second issue in second case is filed.
Yes.
So doesn't the judge has to apply his judicial mind there कि there is another issue is also there and it could be judged upon?
So how will the judge come to know, Raghav? Like, for example, in this case, the person went to the court and challenged that my dismissal is not proper because I was not given a chance of hearing. The judge does not have the time, energy, and he is not even supposed to look into the nitty-gritties of your matter. Judge is going to look at the matter as you present it before the court. Agar aap jaake kehte I was not given a chance, then the court will only look at the point whether you were given a chance to be heard or not. How will the judge know whether you were appointed by this authority or removed by this authority? See, until an Indian judiciary system, it works until and unless you bring the matter before the court is not going to hear that matter. The court will not itself take up issues. It will not itself, although it should, it is in the interest of justice and all that, I do understand. But then that is not how Indian judiciary system works.
All right, ma'am. But ma'am, in CRPC there are provisions like in CRPC.
See, CRPC is a criminal law. We have section 311, we have section 313, we have section 165 of Indian Evidence Act. Now, section 165 of Indian, yes, we have 313 of CRPC, 311 of CRPC. They are basically systems which deals with the inquisitorial system.
Yes, ma'am.
Right? We have two kinds of system, adversarial and inquisitorial. In inquisitorial, the judges are more proactive, right? So, section 165 and all these deals with basically the inquisitorial provisions where the judges are very active. And they are required to be so because these are criminal matters and the punishments are high, the stakes are high. However, in civil matters, the stakes are only money and property and all that, not in the sense of life of a person and all that. So that is why we do not have these provisions in civil law.
All right.
Right?
All right.
Alright. Plus, any other question? Anyone? Okay. Now I move to the second concept that I discussed in the last class, and I also do a case on it. And the second concept is order to rule 2. Now what does order to rule 2 say? Anyone?
Cause of action.
Cause of action, right. What about cause of action? Anyone? Class, and it's okay, you can be wrong, you're students, even teacher can be wrong, that's fine, don't worry about that.
Ma'am, it says that the suit must include the entire claim, and if the plaintiff wants to bring the suit within the jurisdiction of any one court, he must relinquish the other portions of the...
Okay, fine. See, what order to rule 2 basically says, it deals with the relief part of it. Whatever relief, when a person is filing a suit, whatever relief he is wanting the court to give, the person must mention that relief and ask for all the reliefs that are possible, right? In a suit, if a person is entitled to more than one relief, for example, I gave you the example of breach of contract. In case of breach of contract, a person is entitled to specific performance of the contract, and a person is also entitled to damages. So these are the two reliefs that you can ask from the court. If you ask for only one of the reliefs and not the other relief, ठीक है, और आपका केस मान लीजिए द कोर्ट हैज गिवन अ डिक्री अगेंस्ट यू एंड यू आर नॉट गिवन दैट रिलीफ. नाउ यू वांट टू फाइल अ फ्रेश सूट टू क्लेम द अदर रिलीफ व्हिच यू डिड नॉट आस्क फॉर. आपने पहले सूट में सिर्फ डैमेजेस मांगा, कोर्ट ने रिफ्यूज कर दिया. आप दूसरा सूट फाइल करते हैं सेम कॉज ऑफ एक्शन पे. नाउ यू आर आस्किंग फॉर स्पेसिफिक परफॉर्मेंस ऑफ कॉन्ट्रैक्ट. नाउ ऑर्डर टू रूल टू से दैट यू कैन नॉट डू दैट. You cannot, whatever relief are possible in the same cause of action, you should ask for all the reliefs in one go. You cannot keep on filing suit again and again to claim other relief. That is one part of order to rule 2. Okay? Second part of order to rule 2 says that if there is a certain amount of money, let me give you an example of money. If there is certain money that you can claim, that you are wanting to claim from a person, if you relinquish any portion of the claim, for example, किसी से आपको 20 लाख रुपीस किसी ने आपसे लोन लिया है, and you are filing a suit against this person, you are filing. Who is trying to enter the class from the name Gupta Traders? Class, where are these links going? Who's Gupta Traders and trying to enter the class? Okay, fine, no issues. I've denied. Okay. Now, where was I? All right. I was talking about the first aspect of order to rule 2, which says that if somebody has taken a loan of 20 lakh rupees from you, and you have to file a suit. Now you think, no, let me file a suit for only 15 lakh now, and because it comes within the jurisdiction of civil court, so abhi to main civil court senior division, I'll ask for 15 lakh rupees now, and I'll file another suit and I'll take 5 lakh later on. This is not allowed. Whatever claim that you have from a person, all this claim should be included in one suit itself, because we do not want multiplicity of suit, right? So if you are not asking for the claim in the first suit, then the second suit will be barred, right? कई बार आप क्या करते हो? You relinquish your claim. Relinquish your claim is you leave your claim. Okay, I don't think this person will be able to give 20 lakhs, so let me file a suit only for 10 lakhs. That is absolutely fine. Or you want the case to go to a lower court, that is why you file a suit of not 20 lakhs but only 10 lakhs, right? That is again fine. But then later on, if you want to claim the remaining amount, that you will not be able to. That has been barred by order to rule 2. Plus, is order to rule 2 clear? If there is any doubt regarding this, please ask. Then yes. I'll do a case. Yeah. Okay. Anyone having any doubts, please feel free, class. You're free to ask. Please do that. All right, good. So what we're going to do is we are going to do a case which deals with order to rule 2. And the case is C.A. Balakrishnan versus Commissioner Corporation of Madras. I'll repeat the name of the case. And the case is C.A. Balakrishnan versus Commissioner Corporation of Madras. Now, this is a case which basically deals with the provision that does order to rule 2 apply in case of writ petitions or not, right? So the whole issue is that we know order to rule 2 applies in the case of normal suits, but now the issue before this court is whether order to rule 2 applies in case of writ petitions also, which means if a person has filed a normal suit and there is certain kind of relief that he could ask for, he did not ask for, now he goes to the court and he's asking for filing a writ petition and asking for some other relief, asking for, let's say, a writ to be issued, right? So will order to rule 2 apply on that also? So let's see what the court basically said it does apply. So let's look at the facts of the case. Now what are the facts of the case are that there is a person and he is basically the petitioner earlier. Sorry. Just give me a moment. All right. Now, there is a person, he is the petitioner. Now, this person is running a canteen. And he is running this canteen by the name of Udupi Canteen. I'm sure a lot of you must have heard of Udupi. It's very popular for what kind of dishes? Kaun si dishes milte Udupi mein?
South Indian.
Yes,
South
Indian dish. Yes, South Indian, right? So this person was running a canteen in the state of Madras, and he was running Udupi canteen, and he got the license to run this canteen from the corporation. The municipal corporation gave him the license. Now this person had been, he was not the original licensee. Earlier this canteen license was given to someone else. Later on the license was given to this person and all that. So what this person did, he was doing everything that legally he is required to do, which means that he was paying his monthly rent, whatever rent was due, he was paying that rent also. And he also took a license from police for running the said canteen. He also got clearance from the labor department, because whenever you're running these things, you need to get clearance from the food, the health department, the labor department, police, no objection, everything. So all kind of things he has got, right? In fact, he also asked for no objection certificate from the revenue officer, and this NOC was given to him, and after that he was running his canteen peacefully. And around 20 people were working in there. Now what happened is, one fine day, it was peak hours, it was actually lunchtime, and a junior engineer barged into the canteen, and he asked all the staff and all the office members, all the customers to just leave the canteen, and he basically sealed the canteen. Now at that time when he sealed the canteen, there were a lot of perishable items that were there, were a lot of 20,000 worth edible material was there. There was milk which was worth more than 6,000. Then there was coffee, Horlicks, betel nuts. Everything was there around 20,000. So all these perishable items were lying there, right? Now at the time when these things happened, the High Court was on vacation. That was at the vacation time this incident occurred. Now what happened is, this person filed a case. He basically filed a suit in the city civil court, and in the city civil court he asked for the relief of a mandatory injunction, and he also asked for he demanded the restoration of possession and payment of damages, right? He wanted that a mandatory injunction should be issued, his premises should be restored back to him, and damages should be paid to him, right? Now, what happened is, the city civil court basically granted him the relief that you can take your perishable items. So the lock was removed and he was allowed to take his perishable items. And no other relief was given to him, right? Now, in the meanwhile, what happened, the courts opened, and as soon as the court opened, this person went ahead and filed a writ petition to the High Court. And in the writ petition, what is he asking for? He is asking for a writ of mandamus. What is a writ of mandamus? Quickly, tell me. What do you ask for a writ of mandamus?
Ma'am, the High Court or Supreme Court can command the lower court to do something.
Ask a lower court to do something, or ask a public officer to do his duty?
Public officers, I think it's a few warrant to by what authority?
Anyone else? Public officer. See, what happened in mandamus? In the writ of mandamus, the court can order the public officer to do his official duty that he should be doing it. So do his basically legal duty, or the official duty he should do, right? So as soon as the High Court reopened, this person filed a writ, and in the writ, what he asked for is, he asked for a writ of mandamus to be issued. He wanted the restoration of his property. He wanted a mandatory injunction, and he wanted damages also, right? Now, in this case, the opposition, it was the state government and the municipality, they said, look, this writ is not maintainable because it is hit by order to Rule 2. He is asking for a relief which he did not ask for earlier. He never asked for mandamus. He never asked for this other relief that he's asking here earlier. So that is why this order to Rule 2 should not be, is going to apply on the matter. So in this case, by and large, leave about the facts are not so important, but the basic law point that you must know in this case is, the issue before the court was whether order to rule 2 applies to writ petitions or not. That was the whole issue, law point that you need to know in this case. Now, the court said, look, we have order to rule 2. When we look at order 2, and this is given in para 7, as and when you get your case match. Now, para 7, what does it say? It says that it is evident from order to rule 2 CPC that a suit shall include the whole of the claim. The relinquishment of part of claim is not permissible, and omission to sue on one of the several reliefs is also prohibited. Hence, once a suit is filed for certain relief in respect to a cause of action, the person who has filed is precluded from instituting another suit for certain other reliefs with the writ jurisdiction in this court for obtaining the very same relief. Instead, if second suit is barred, writ petition would equally be barred. Public policy underlying order to rule 2 is attached equally to the vigor of both the situations. So what this basically means is that just like order to rule 2 will order to rule 2 will apply on another suit, similarly, a writ does not stand on a different footing. Writ is as good as another suit. So if it applies on another suit, order to rule 2 bar is also going to apply on the writ petition, right? So in this case also, what did the court say? Court said that just a moment. Okay. It says a person who files a suit seeking certain relief, and this I'm reading again, it is para 7, continuation of para 7, para 11, this is para 11. It says a person who files a suit seeking certain relief in respect to a cause of action and who is precluded from instituting another suit for seeking other relief with respect to the same cause of action cannot be allowed to invoke the writ jurisdiction of the court for obtaining the very same relief. Instead, if a suit is barred, a writ petition would equally be barred. Public policy says this, right? So in this case, what happened in this case was, कोर्ट ने ये भी बोला कि कंस्ट्रक्टिव रेट जुडिकेटा भी रेट पिटिशंस पे लगता है, वो तो हमने लास्ट केस में देख के लिया. Now in this case, what happened was, in the meanwhile, while this writ to the High Court was still pending, the lower court gave a decision in favor of the plaintiff itself. And this fact was hidden by the plaintiff from the High Court. They did not inform the High Court that a decree has come in favor of, a suit is still pending. So this fact was also hidden. So एक suit तो pending already था, same relief के लिए, बिल्कुल same relief claim करने के लिए और एक additional relief claim करने के लिए you filed a suit in the High Court, right? So the court said that order to rule 2 will apply because whatever relief you could have asked, you should have asked from the earlier court itself. So basically, forget about the facts. The facts are not properly given in this case because a lot of things I find missing when I was reading this case. Lower court का क्या decision था, this has not been given clearly. And the facts are also little, not clearly given. So editing has not been done properly. But what you need to understand the law point, and the law point that was said in this case was that will order to rule 2 apply on writ petitions also, or does it apply only on normal suit? The answer to this question is that order to rule 2 applies equally to a writ petition as it applies to a normal suit. Fine, class? So just try reading it. Do not go too much into the facts because I also found them very not very clear. Fine, class? So just keep this thing in mind that order to rule 2 applies to writ petitions also.
Yes, ma'am.
Alright. So today I will not be taking attendance because I have a software downloaded. उसमें आपकी attendance automatically आ गई है. So don't worry about that. Right? So that's all for today. If anyone has any questions, they are free to ask.
Ma'am?
Yes, Nishant.
Yes, ma'am. Ma'am, in this case, order to rule 2 was invoked because the party tried to get the order of mandamus issued. Right?
Yes.
Ma'am, but
and also
right that
the High Court can only give mandamus and the lower court cannot. I know. The same issue came to
Yes,
my...
ma'am. So that was the doubt. So.
Exactly. That is my doubt as well, because the editing has been done very poorly in this case. So since the facts and release and nothing has been given clearly, so that was my doubt also. But there are certain other releases also, like he asked for mandatory injunction, but possession, I don't know. The facts are not clear in this case. So that's why I said
okay, ma'am.
go on, they concentrate on the law point. All right, class, that's all for today, and thank you so much for joining. Thank you so much, class. If you want, you can leave. Thank you.
Thank you, ma'am.
Thank you, ma'am.
Welcome. Thank you so much. Goodbye. Take care.
Ma'am, will you not be taking physical attendance today?
Not today. I'll just check my software. If it is working fine, then I'll not. Don't worry. You'll not lose out on attendance. I think it's taking it fine.
I just asked
if there is
I joined recently.
No, that's fine. If there is some problem with the software, then I'll again shift to the physical one. Let me see. Let me check today. Right? The complaint was filed against Nawab Hussain under Prevention of Corruption Act. Now, thereafter, what happened is that proceedings started against him, and he was dismissed from service. Now, obviously, he was aggrieved by this decision. So, what did he do? He basically he filed a writ to the Allahabad High Court, and in the writ he contended that my dismissal from service, this is basically a service matter, he said my dismissal from service is not justified and is not a right decision that has been taken, and the reason is that I was not given any opportunity before I was dismissed. Now, when you do administrative law, you would come across a concept of audi altrum partem. Now, audi altrum partem basically means a chance of being heard. Now, this is one of the principles of natural justice, that before you are taking a decision against someone, before you are giving a decision against someone, you are supposed to give that person a chance of hearing, right? And this person said that I was not given any chance of hearing before my dismissal, so that is my ground. And on this ground, he filed a writ. Now, after hearing the writ, the High Court came to the decision, no, his ground is not justified, and he was not given any relief by the High Court, right? Now, thereafter, what he did? Thereafter, this person filed a suit. He filed a civil suit. And in the civil suit, again, he is, yes, Komal, you're right. Here the other party. Yes. No, not the other party. Here the party against whom you are taking the decision. That is audi altrum partem. अगर मैं आपके against कुछ disciplinary action ले रही हूँ, then it is my duty to give you at least a chance for clarifying your position. That is audi altrum partem. Right, Komal? And that's okay. But that is what audi altrum partem means. Fine? Now what happened is this person...
दोस्तों, ब्रास फ्यूजन आशा करता है कि आपको हमारा लेसन पसंद आया होगा। कमेंट बॉक्स में अपना फीडबैक देना ना भूलें। थैंक्स फॉर वॉचिंग।